You've said that you've had no complaints from local authorities secure children's homes about the use of restraint in such homes, or lashes as we call them. What do you think are the characteristics of lashes that lead to there being no complaints from that source? Is it that they don't do it, they do it better, or that in fact they de-escalate much more successfully, or a combination of all three?
I'm sure other witnesses will be able to comment on the frequency at secure children's homes. I don't think it's that they don't do it. I think actually they are sometimes dealing with some of the most challenging young people, and I have heard of restraints taking place, and I've been in secure children's homes when that is happening. However, they do seem to be used in accordance with the rules, as an absolute last resort, with the minimum force that is necessary, and in circumstances where it really, often I talk to children, they can be very kind of critical judges of their own behaviour actually. And quite often when I've talked to children who have been restrained in secure children's homes, they may on occasion say, well, I understand why that happened, and I was, acting in such a way that perhaps necessitated that. But I've also talked to members of staff who said, actually, sometimes we may spend 8 hours in the art room waiting for someone to calm down because it was not necessary to intervene and hurt them. We just invested the time, and they did calm down. So I think there's a very strong difference of approach.
Do you think that it is practical for that different approach to be taken up in other institutions where staff may work under greater pressure than in a local authority secure children's home?
I think it's practical, and I think it's essential, because the detriment of not doing so is, of course, cycles of violence and increases in reoffending and general unhappiness. So the resource implications of over restraining young people are actually equally damaging. So, but it would take a fundamental shift and quite a lot of investment to start with.
Now, I think you're certainly the only lawyer giving evidence today in that capacity. So from your capacity as a lawyer who is plainly expert in these matters, could you just explain to everybody present the basic legal rules about when restraint can be used?
Yes, I mean, the rules are governed by the STC rules, the YOY rules, and of course basic fundamental human rights. And without sort of dryly taking you through each of those rules, there are sort of 3 key features that are common to the 2 sets of rules. The first is that restraint should only be used when it is strictly necessary. It really is a disaster mechanism. It is to prevent injury to self or another. So, where there are no alternatives available. Unfortunately, this is one of the key things that I see not happening. For instance, I'm thinking of 2 clients that I've worked with who describe in detail being heavily restrained in their cells in situations where the officer could have simply left them, but they chose not to leave the room to restrain the young person. The second feature is minimum use of force necessary. Now, we hear a lot about PCC being the overwhelming or overpowering use of force. The legal requirement is that when a restraint is used, it must be only the minimum force necessary to deal with that situation. Again, lots of children complain to me that they sense officers getting carried away. Some children describe it to me as a sort of power trip where officers continue to restrain a young person even after they have stopped struggling, which you can imagine may will happen when there's adrenaline involved. And the third common feature is provocation. Children must not be provoked into a restraint situation, which again appears to be quite a major problem.
Where it is alleged that those legal rules that you've just described very clearly have been breached, and therefore you as a practicing lawyer take steps to maybe bring an action on behalf of a child who's been restrained, what level of cooperation do you receive from the prison service in the legal process? And you might like to compare this with the ordinary legal process of which you have some experience, I think, where other potential defendants are involved.
Yeah. legal redress in this area is, I suppose I could describe it as inaccessible curmudgeonly at best. First of all, lots of children are not aware that they can get legal help to deal with an issue like this. They're not aware that in fact they may have a claim in damages if they've been severely injured or even just injured. So often it doesn't even occur to them that they can get free legal assistance. The response from prisons and STCs, almost entirely in my experience, is very closed. It can take years to get disclosure. Often when disclosure comes, it is heavily redacted, so it's very hard to take instructions. You're talking about something that's happened in the heat of the moment anyway, and so 12 months later, trying to talk to a 15-year-old child about, well, is this account accurate, when the names have all been redacted, makes it very hard for that young person to give you clear instructions. And the complaint system, even when it is pursued, is extremely slow and generally appears to be rather self-serving, I'm afraid.
When I was carrying out the evidence obtaining phase of the 2006 inquiry, I was told that information would be made readily available, if it was not already, in all institutions, so that any child held in an institution would not only know where to turn for complaints or legal advice, but would be facilitated by the provision of a telephone, for example, in being able to do so. How far have we come since then in fulfilling those promises?
Complaints, most children, I was actually talking to some children about this just a few days ago, most children know they can complain. The problem is they say there's no point because no one's going to believe them anyway, and so there is this sense of total worthlessness and powerlessness to do anything. So the complaint system is a problem in that way. There have been good developments, I think, since 2006 in terms of advocates in every institution. The problem is as a lawyer, I'm struggling to get answers, and I don't see advocates getting much further in those that I speak to. In terms of legal advice, that is very poor. In terms of facilitating access to legal advice for children, as Article 12 of the UN Convention suggests, is absolutely crucial. We know that even though YOIs are required by the PSO, Prison Service Order system, to have legal officers, I don't think I know of one legal officer in a single YOI for children. So facilitating legal advice. And actually another problem is that institutions often consider a complaint brought by a lawyer on behalf of the young person as almost sort of not a proper complaint, which is sort of shows a really fundamental misunderstanding of the role of lawyers as advocates for their clients.
At a private meeting